Welcome to the Luxembourg Fundcast.
Great to be here.
Today we're diving deep into legal opinions in Luxembourg. They're, a real cornerstone of the legal and financial landscape here.
Absolutely. They really are.
We'll explore why they're so crucial, who's involved in creating and using them, where they pop up.
How they're put together.
Exactly. And, of course, the recent big developments.
Right.
Our mission today is really to unpack this expert tool, try to clarify some of the complexity, and highlight why this matters to you, especially if you're a professional in law, finance, corporate governance, or compliance here in Luxembourg.
That's right. And like you said, legal opinions in Luxembourg, they're more than just general advice. Think of them almost as a definitive confirmation of the legal elements within a specific transaction. We're going to really dissect this vital instrument, look at its purpose, the key players, the scenarios where it's essential, its typical anatomy, and what's changing right now.
Perfect. It's about getting to the heart of what can seem like a pretty sophisticated tool. So let's start right at the foundation. What exactly is a legal opinion here in Luxembourg? How is it different from just, everyday legal counsel?
Okay, so a Luxembourg legal opinion, it acts as a formal statement, an attestation really, confirming that specific legal aims within a deal have been met.
So a confirmation.
Yes. And unlike legal advice, which often looks ahead, guiding future actions, an opinion is more definitive. It's a statement on the legal state of play right now for a particular transaction. And that distinction is critical, especially in complex deals, maybe cross-border, high-value ones, where it gives that much-needed certainty and helps manage the risk involved.
So it's less a forecast of potential legal weather and more like a surveyor's report confirming the current legal ground for that specific deal.
Precisely. You could say they're expert tools for actually completing transactions, for navigating those tricky risks and steering complex processes.
Right.
But it's worth mentioning, getting these opinions, it can lead to more scrutiny, higher costs, maybe longer timelines too.
That makes sense.
And for anyone listening who's more familiar with common law systems, it's key to remember this concept, though established here now, has its roots in common law. It's been adapted for a civil law place like Luxembourg, so it needs a kind of nuanced understanding, especially for international practitioners.
That's a really interesting point about the common law transplant. So what actually drives the need for these confirmations? Why are they required or, sought after so often?
Well, primarily it's transactional imperatives. For major deals, legal opinions are often indispensable. Think about lenders, investors, acquirers. They rely heavily on them for assurance on critical legal points before they commit significant resources.
Okay, so assurance before commitment.
Exactly. We see it a lot in lending and finance. And they're particularly vital in securitizations, things like confirming the unregulated status of the SPV, or that its center of main interests, the COMI, is indeed in Luxembourg. The fundamental need is just for certainty about the legal soundness, the enforceability of rights and obligations.
Got it. So mitigating risk in those high-stakes deals, what else makes them so important?
Regulatory demands. They're playing an increasingly significant role.
The regulators.
Yes. Both EU and national rules are more and more explicitly requiring, or at least strongly implying, the need for opinions or similar confirmations. A prime example, the EU's MiCA regulation markets in crypto assets.
MiCA, right. We hear a lot about that.
It actually mandates a legal opinion on how asset-referenced tokens, or RRTs, are classified, and that has to be submitted to the CSSF here in Luxembourg.
Wow. Okay, so a specific mandate there.
Yes. And while our sources don't definitively state a blanket requirement for external opinions across all CSSF-supervised entities in every single scenario, the detailed authorization and supervision frameworks, say for investment firms and management companies, they often involve legal confirmations. These could well be opinions needed to show compliance with complex legal and regulatory criteria.
So the CSSF relies on this legal validation.
Essentially, yes. Regulatory bodies leverage expert legal assessments as part of their oversight function.
Okay, so it's not just the deal itself needing to be sound, but also about meeting regulatory expectations.
Precisely. And finally, it really boils down to bolstering overall legal certainty and the enforceability of agreements.
Right.
By formally confirming the legal validity of arrangements, making sure rights and obligations are enforceable, these opinions contribute to financial stability and ultimately strengthen investor confidence.
That makes sense.
Even looking at CSSF enforcement actions regarding accurate financial information, while not directly about transactional opinions, it highlights that broader regulatory focus on precise advice, legal and financial representation, and opinions play a key role in establishing that accuracy.
Okay, so we've covered the why. Now, what about their legal standing? If an opinion's issued, what weight does it actually carry in a legal context here?
That's a good question. Luxembourg law doesn't actually assign a specific binding weight that courts must give to transactional legal opinions.
Oh, interesting.
But given their formal nature, the reasoning behind them, the fact they aim to be definitive, well, it suggests they'd likely carry considerable persuasive authority if presented in court.
Persuasive, but not automatically binding.
Exactly. Ultimately, whether it's admitted and how much weight it's given would be up to the judge, based on the case specifics, the opinion's relevance, the credibility of whoever issued it. It's different, from the formal requirements for written witness statements in Luxembourg law, which have very specific formality.
Right. One's expert legal analysis, the other's factual testimony. Got it. Now, legal professional privilege LPP, that's fundamental for lawyers everywhere. How does LPP intersect with legal opinions here?
Oh, it's a critical connection. Generally in Luxembourg, communications between a lawyer and their client are protected by LPP. And that protection covers the content and analysis within a legal opinion. But there's a really significant recent development here.
Oh.
Yes, the Advocate General's opinion in a CJEU case, C43223. The AG suggested that EU charter rights give comprehensive protection to all legal advice. That includes tax and company law advice.
All legal advice. That sounds broad.
It is. And it challenges current Luxembourg law, which actually limits LPP for tax advice unless not disclosing it risks criminal prosecution.
So a potential conflict there.
Right. The AG argued that forcing disclosure of all available documentation on client advice, including opinions, infringes LPP, and that a blanket exclusion for tax advice without looking case by case goes against the EU Charter.
So what happens if the main court agrees?
Well, if the CJU follows this opinion, it could seriously broaden LPP for tax-related legal opinions in Luxembourg. That means potentially greater confidentiality and impacts on cross-border tax information exchange.
Wow, okay. That's definitely one to watch.
Yeah.
Now, we often hear the term avis juridique. Is that just another name for the legal opinions we've been discussing?
Not quite. Well, avis juridique translates to legal opinion. It's often used in specific official Luxembourg contexts, which are different from the private transactional opinions we're focusing on.
Ah, okay. Like what?
For instance, the Conseil d'État, the Council of State, issues formal avis on draft laws and regulations. They assess legality, constitutionality.
Right, part of the legislative process.
Exactly. And those are public documents contributing to overall legal certainty. The Parliament, the Chambre des députés, also uses avis juridique, maybe from its own scientific unit or external experts they commission, to inform their scrutiny of legislation.
Okay.
And you'll also see avis juridique, or legal opinions, submitted by parties in court cases, especially if there's a point of foreign law, though again, the court decides the weight.
I see.
Even the AED, the tax authority, explicitly states its general information bulletins are not intended to be a formal avis juridique, which really underscores the formal, potentially binding nature of a true legal opinion compared to general guidance.
That distinction is helpful.
And we are seeing a trend, like with MiCA, towards more formality and sometimes mandatory opinions. It suggests regulators are relying on them more, moving beyond just transactional assurance towards direct compliance checks.
That makes sense. So let's talk about the who.
Oh.
Who are the key players in this legal opinion ecosystem? Who typically issues them and who relies on them?
Okay, on the issuing side, it's primarily Luxembourg qualified lawyers and law firms. The avocat à la cour, and established practices with that deep, specialized knowledge of Luxembourg law and practice.
The local experts.
Exactly. Think of well-known firms active in this space. Their qualification by the Luxembourg Bar ensures they meet professional and ethical standards. Now, in-house counsel can provide opinions for certain regulatory needs. MiCA, for example, allows this for the RT qualification opinions.
Interesting. So in-house is possible sometimes.
Yes, but generally for significant transactions where a third party is relying on the opinion, external independent firms are preferred. It's about perceived objectivity.
Right, that independence factor.
Yeah, absolutely. The credibility really hinges on the issuer's qualifications and independence. And newer rules like MiCA actually spell out specific criteria for this, like being free from unmanageable conflicts of interest.
Okay, and on the receiving end.
Yeah.
Who are the main users, the ones placing trust in these documents?
Primarily, it's the parties directly involved in the transaction.
D participants.
Right. Lenders, investors, acquirers in M&A deals, underwriters in capital markets, other key players. They're looking for assurance on critical legal points for their risk assessment, their due diligence, their decision-making. Okay. You see this across lending, finance, securitizations, derivatives. Often, getting satisfactory opinions is a condition precedent the deal can't close without them.
A crucial step, then. Who else relies on them?
Regulatory bodies are significant recipients too, particularly for authorizations, ongoing supervision, and checking compliance.
Like the CSSF.
Exactly. Now, as we mentioned, our sources didn't show a universal rule for external opinions for all CSSF authorizations.
Yeah.
But the detailed criteria they assess for, say, management companies or investment firms, legal form, capital operations governance strongly imply a need for legal validation.
Right.
That often comes through submitted or maybe internally held opinions.
Okay.
And under MiCA, as we said, those RT qualification opinions must go to the CSSF. Even courts and arbitral tribunals, they receive opinions, the avis juridix, as evidence in disputes, especially on complex points of local or foreign law, helping clarify things for the judge or arbitrator.
So a real mix, commercial players, regulators, even the courts sometimes. Let's dig a bit deeper into the roles of the regulatory bodies. What's the CSSF's specific role here?
Well, the CSSF is central. Its own legal department manages its legal powers, liaises with judicial authorities, and might even hire external legal advisors suggesting they could seek opinions themselves.
Interesting.
They authorize and supervise a huge range of financial entities. And while, again, maybe not a blanket external opinion requirement for every single authorization, the detailed checks they do on legal form, capital, operations, governance, the reputation of key people, that all points to a need for solid legal validation, often through opinions. CSSF circulars provide specific requirements too, like the one implementing ESMA's MiCA opinion guidelines.
So circulars are key here.
Very key. The CSSF also enforces the accuracy of financial info, and they're the competent authority for MiCA receiving those RT opinions. They're really shaping the regulatory field where opinions are essential for proving compliance, especially with big new regulations like MiCA and DORA.
Okay, a pivotal role for the CSSF. What about the tax authorities, the AED and the ACD? How do they fit in?
Their focus is different, naturally. The AED supervises certain entities, including unregulated AIFs for AML-CFT purposes.
Anti-money laundering.
Right. And they require reports like the RC report and a specific questionnaire. Now, these aren't third-party opinions themselves, but preparing them definitely involves legal interpretation and compliance assessment. Internal legal advice or opinions would be crucial there, especially as the AED is signaling tougher AML enforcement.
So opinions feed into those reports indirectly.
Exactly. Then there's the ACD, dealing with direct taxes. They explicitly state they don't act as independent tax advisors, which really highlights the importance of getting external tax opinions for complex situations or confirming tax positions, particularly relevant now, given that AG opinion about LPP potentially broadening for tax advice.
Right, that potential shift again.
Our research didn't specifically show the AED or ACD demanding formal third-party opinions in many cases, but they operate in legally intensive areas where firms and taxpayers rely heavily on legal advice and, likely, opinions.
Understood. And what about the European level? ESMA and the EBA. How do they influence what happens in Luxembourg?
They have significant and growing influence through their guidelines and binding technical standards.
So setting the EU-wide rules.
Pretty much. These can directly mandate or shape opinion requirements in member states, including Luxembourg. The joint ESMA guidelines with the templates for MiCA art opinions are a perfect example.
Right, the templates.
And ESMA issues guidelines on other things, too, like fund names, which might indirectly mean legal review or opinions are needed for compliance. National regulators like the CSSF have to make every effort to comply with these ESA guidelines.
So it drives harmonization.
Yes, it leads to more harmonization and directly affects how opinions are approached here. It's clear that both EU and national regulators are increasingly relying on opinions or legal confirmations, especially in new areas like crypto. It's interesting they sometimes accept in-house opinions, like for MiCA Arts, but always with that strong emphasis on objectivity and managing conflicts.
It sounds like a whole interconnected ecosystem.
It really is. Regulatory shifts or big legal interpretations create ripples right through the system.
Okay, we have a clear picture of the who. Now let's shift to the where. In what typical transactions and scenarios are legal opinions usually needed here in Luxembourg?
Well, there's standard practice across a wide range of activities. In finance, for instance, they're typical in most lending deals. They confirm things like the borrower's legal capacity, that the agreement was properly executed, that it's enforceable, regulatory compliance, the basics, really.
Standard checks for lenders.
Exactly. In capital markets debt or equity offerings, opinions are routinely given to the issuers, arrangers, underwriters. They cover the entity's existence, that the securities are authorized, compliance with securities laws, disclosure rules, listing requirements.
Lots to confirm there.
Yes. For derivatives, often under ISDA master agreements, opinions look at the enforceability of closeout netting, collateral arrangements, and counterparty capacity. Regulators also often mandate updated opinions for repo deals done under GMRAs, partly for netting benefits in capital calculations.
Right, netting is key. So it seems whenever there's significant money or complex rules involved, opinions are likely. What about investment funds?
Absolutely central there, too. For fund establishment and authorization, while the CSSF might not demand an external opinion for every single step, the detailed requirements they have for mancos and investment firms, legal form, capital operations, governance, they strongly imply a need for thorough legal review and confirmation, often through submitted or internal opinions.
Okay.
And then there's ongoing compliance, adhering to laws like AIFMD, UCIs, various CSSF circulars on AML, DORA for operational resilience, that frequently requires legal validation.
Makes sense.
Even the recent ESMA guidelines on fund names that will likely involve legal review, maybe opinions, to ensure names comply with the strategy.
And I imagine securitization is another big area.
Definitely. Luxembourg has its own dedicated securitization law. Opinions here are crucial. They cover bankruptcy remoteness, true sale of assets, enforceability of security, compliance with the EU securitization regulation, including risk retention rules.
Key aspects for investors.
Precisely. Opinions often confirm specific warranties, too, like the vehicle being unregulated, asset management compliance, compartment separation, AIFMD not applying, and the co-MI being in Luxembourg. The CSSF's own FAQ on the law clarifies principles that opinions typically affirm.
Okay. And moving beyond pure finance, what about general corporate matters?
Yeah, even there, standard opinions confirm things like due incorporation, that the company was set up properly, validly exists under Luxembourg law.
Basic corporate health check.
Exactly. And that it has the necessary corporate capacity and authority to enter the transaction and perform its obligations. This involves checking constitutional docs, RCS excerpts. It's foundational assurance for most deals involving Luxembourg entities.
Got it. And given Luxembourg's international role, cross-border deals must heavily rely on these.
Hugely important there, yes. Multiple legal systems involved make opinions even more critical.
Right.
They address things like which law applies, enforceability of foreign judgments in Luxembourg, conflict of laws. Opinions often confirm the validity of choice of law clauses under the Rome regulation, which Luxembourg courts generally uphold, subject to public policy exceptions.
So bridging legal systems.
Essentially. Many opinions focus on Luxembourg law, but are vital for larger international deals governed by, say, English or New York law, especially common for IZA agreements.
Okay, so deeply embedded across the board. Now, thinking about jurisdiction, they primarily focus on Luxembourg law, correct?
Yes, that's the main focus. Issued by Luxembourg lawyers, they naturally cover the Grand Duchy's laws, regulations, case law.
But EU law plays a big role.
A massive role. Luxembourg law is heavily shaped by and must conform to EU law. EU regulations like MiCA, DORA, AIFMD, EMIR, they're directly applicable or transposed, so opinions have to consider this EU dimension.
Makes sense.
And CJ-EU interpretations, like that potential LPP shift we discussed, have a profound impact. In cross-border deals, a Luxembourg opinion will focus on Luxembourg law, but often needs to address the interplay with the chosen foreign governing law, which, as mentioned, Luxembourg courts generally respect under Rome, barring public policy issues.
So it's Luxembourg law operating within and interacting with a strong EU and sometimes international legal context. If someone needs to find the actual legal framework details, what are the key official sources here?
Okay, for authoritative sources, Legilux, that's legilux.public.ue, is the official gazette. Primary source for national laws, regulations, official acts.
Legilux.
Got it. Then guichet.lu, that's the official state info portal. Good for context on procedures, public services, but not a primary legal source itself.
Okay.
Justice.public.lu is the Ministry of Justice portal. You find national court decisions there, info on the judicial system crucial for interpretation.
Right, for case law.
CHT.lu is the Parliament site, draft laws, legislative records, parliamentary questions, official reports, sometimes opinions commissioned by them.
Useful for a legislative background.
Definitely. Then for the EU level, EUR-Lex, ir-lex.europa.eu is the gateway to all EU law. Official journal, treaties, directives, regulations, CJEU case law. Indispensable.
UR-Lex, essential for the EU piece.
And finally, curia.europa.eu is the CJU's own website for direct access to its judgments, orders, AG opinions. Robust opinions are always grounded in these official sources, and the growing complexity, MiCA, DORA, just reinforces the need for deep legal specialization.
Absolutely. Okay, we've covered why, where, and who. Let's move to the how. What different types of legal opinions do we typically see?
Well, there are several key types. Capacity opinions confirm an entity's power and authority to enter a deal.
Can they actually do this?
Exactly. Enforceability opinions confirm the contractual obligations are legal, valid, binding, enforceable under the governing law.
Will this contract hold up?
Right. Then you have regulatory opinions focusing on compliance with specific frameworks, investment fund laws like UCITS or AIFMD, MiCA for crypto, AML-CFT rules, DORA for digital resilience.
Ticking the regulatory boxes.
Precisely. Tax opinions assess the likely tax treatment of deals, entities, or structures under Luxembourg tax law.
How will this be taxed?
Yes. And then there are other specific ones. No conflict opinions, confirming a deal doesn't clash with governing docs or other laws. Perfection opinions for secured deals, confirming security interests are properly established, and opinions related to prospectuses and securities offering.
The whole toolkit of opinion types.
Yeah.
Now, what about their structure? What are the common building blocks inside a typical opinion?
Okay, so while there aren't official Luxembourg templates for general transactional opinions, the MiCA Art opinion template is the big exception there.
Right.
They generally follow a fairly standard format. You'll typically see who the opinion is addressed to and who can rely on it. The date is crucial. It speaks as of that date.
Okay, addressee reliance date.
Then a list of all documents reviewed the basis for the opinion. After that, the core confirmations. Due incorporation, valid existence, corporate power capacity, due authorization for the deal.
The key legal confirmations.
Yes. Confirmation of valid execution and delivery of documents. A central part is the enforceability clause, saying obligations are legal, valid, binding, though always subject to standard qualifications.
The it works but clause.
Kind of. Then a no conflict clause, the deal doesn't clash with the company charter or laws. Maybe clauses on filings or taxes, if it's cross-border with foreign law, clauses on choice of law and submission to jurisdiction.
Mm-hmm.
Critically, every opinion has assumptions, facts taken as true without checking, and qualifications standard limits like bankruptcy laws or public policy. And finally, it states the opinion itself is governed by Luxembourg law.
Assumptions and qualifications sound important.
Very. And for MiCA Art opinions, remember, the template is super specific, demanding detailed analysis of why it is an RT and not something else.
Got it. So that's the anatomy. What's the actual process for issuing one? How does it work in practice?
It usually starts with the client instructing the law firm, defining the scope.
What needs confirming?
Right. Detailed talks happen. What legal questions, what documents to review, what assumptions can be made, who needs to rely on it. Then comes the due diligence by the lawyers.
The homework phase.
Exactly.
Yeah.
Legal research laws, regulations, cases, reviewing corporate records, board resolutions, transaction agreements, certificates from registries like the RCS, maybe some factual checks too.
Thorough.
Has to be. Once that's done, the opinion gets drafted. It usually goes through internal review at the firm for quality and accuracy. Then, often, a draft is shared with the client and maybe the other side's lawyers.
For comments.
Yes, to check facts, the scope of review, the assumptions, before it's finalized and issued.
And I bet there's some negotiation around that draft, some back and forth.
Oh, absolutely. While our official sources don't detail opinion negotiation specifically, it's a very common and often vital part of practice.
What gets negotiated?
Key points are usually the scope, exactly what legal issues and laws are covered. The assumptions, are they reasonable? Do any need checking? The qualifications, are they standard or too broad, cutting back the comfort too much? And of course, who gets to rely on it and how?
Sounds like a balancing act.
It is. The law firm wants accuracy within a clear scope, using reasonable assumptions and qualifications to manage their liability. The recipient wants the broadest comfort possible, with minimal assumptions and narrow qualifications. It's essentially a risk allocation exercise.
Makes sense. What about the cost? Getting a legal opinion, I imagine that varies a lot.
It certainly does. No fixed scale here. Cost depends on many things. Transaction complexity, how novel or difficult the legal issues are, the opinion's scope, urgency, lawyer seniority, time spent.
The usual factors for legal fees.
Pretty much. Fees are based on responsibility, difficulty, outcome, though it's an obligation of means, not results. Firm lawyer reputation, experience. Hourly rates are common, should be clear up front. Initial consults usually aren't free. Fee agreements are possible, maybe with success elements, but pure contingency fees are banned.
Okay.
Statements include fees, expenses, often a percentage, and VAT, 17% currently. Retainers are standard. Fee disputes can go to the Bar Association for assessment. Legal aid might be possible for those who qualify.
Right.
But specific cost breakdowns for opinions aren't really detailed in official sources. The bulk of the cost usually comes from that intensive due diligence, document review, research, internal discussions.
Understandable. Let's talk documentation. What are the core documents underpinning an opinion, and what about the opinion document itself?
Okay, the opinion relies fundamentally on core documents. Constitutional docs, articles of association, corporate resolutions, the main transaction agreements, certificates from registries like RCS, prospectuses if relevant, and obviously the applicable statutes, regulations, key case law.
The evidence base.
Exactly. The opinion document itself, as we broke down, follows that standard structure generally. The big recent change is that mandated MiCA template for RT opinions, very specific content and form requirements there from ESMA, implemented via CSSF Circular 25890.
Right, the MiCA template again.
And it's worth noting how legal changes impact other documents too. Like a recent law amended the labor code here, requiring more info in employment contracts, even allowing electronic format, shows a trend towards more specific legal docs.
And changes trigger updates.
Often, yes. New laws like DORA mean updating ICT risk policies, third-party contracts. MiCA means new white papers, those specific RT opinions. CSSF circular updates might require changes to internal governance or agreements. New RCS filing rules impact corporate records. Legal opinions might then be needed to confirm compliance of these amended documents.
So documentation is constantly evolving.
It's dynamic, needs continuous adaptation to the legal and regulatory scene, often guided by legal advice and opinions assessing the impact.
We've covered the what, why, who, where, and how. Let's tackle when and how long. What are typical timelines for getting a legal opinion in Luxembourg?
Yeah, there's no single answer. It really varies. Depends on the deal's complexity, the opinion scope, how easily available and good the info is, how much negotiation is needed, urgency, external factors like waiting for registry confirmations or coordinating with lawyers elsewhere.
So it could be quick or take a while.
Exactly. A simple capacity opinion might take a few days. Complex one on novel issues could take weeks. Time pressure to close a deal can definitely influence negotiations around assumptions and qualifications too.
Right.
And remember, opinions are often critical path items for closing deals or meeting regulatory deadlines. Think MiCA art opinions needing submission to the CSSF, or DORA reporting deadlines driving associated legal reviews.
So planning is key.
Absolutely. Engaging counsel early is crucial to factor opinion timelines into the overall project plan.
Are there any general procedural time limits in Luxembourg law that might indirectly touch on opinion timelines, maybe relating to litigation?
Well, the official sources mostly detailed time limits for court proceedings, starting actions, procedural steps, court appearances, appeal deadlines, things like that.
Standard litigation timeline.
Right. Deadlines usually start at midnight, extensions for weekend holidays, extra time if defendants are abroad. Failure means actions get time-barred or lapse. There's even a rule about actions lapsing if proceedings stop for 3 years.
Okay.
Now, these don't directly govern opinion timelines, but they're part of the legal backdrop. If an opinion touches on litigation risk, judgment enforceability, or statutes of limitation, then these procedural timelines could indirectly be relevant to the legal analysis within that opinion.
Understood.
Yeah.
Okay, final section, the latest. What are the really significant recent developments and upcoming changes impacting legal opinions here?
There's quite a lot happening. DORA, the Digital Operational Resilience Act, is a big one.
DORA, right?
Yeah.
ICT risk.
Exactly. Fully enforceable since January 17th, 2025. It harmonizes ICT risk management incident reporting, third-party provider risk for financial firms across the EU.
Yeah.
Importantly, DORA and its technical standards now override any overlapping CSSF circulars.
So DORA takes precedence.
Yes. CSSF updated its circulars 2750 ICT security and 22806 outsourcing for DORA entities. They also issued new circulars in April 2025 dealing with PSPs, further DORA alignment, and specific ICT third-party requirements like reporting and maintaining a register.
More reporting.
Definitely. DORA mandates reporting major ICT incidents via CSSF portals. Outsourcing reporting is allowed but needs notification, and responsibility stays with the firm. The documentation impact is huge, updating risk frameworks, incident plans, continuity plans, ICT contracts. We expect more opinions confirming compliance with DORA.
A lot of work generated by DORA. What else is key?
MiCA markets and crypto assets. Aiming for that unified EU crypto framework, key parts expected by end of 2024.
And the RT opinions we mentioned.
Exactly. Articles 17 and 18 mandate submitting a legal opinion to the CSSF on the crypto assets qualification as an ART. CSSF Circular 25890 implements the ESMA-EBA guidelines with those specific templates and tests.
Very structured requirement.
Very. The opinion needs detailed analysis on why it's an ART and not an EMT, financial instrument deposit, etc., referencing the white paper laws cases. Can be in-house or external counsel if objective and qualified. Luxembourg's parliament is working on national MiCA implementation too, giving CSSF crypto sector powers.
So a whole new specific standardized opinion type.
Precisely. Documentation-wise, ART issuers need these opinions. White papers must have them. CSPs need to align everything with MiCA involving legal review.
Okay. Any other major regulatory shifts?
Yes, a few more. ESMA's guidelines on funds names from May 2024 aim for transparency, fighting greenwashing. Fund names, especially ESG ones, must match strategies.
So funds might need name changes.
Or policy adjustments, yes. This means reviewing and possibly amending prospectuses, KIDs, marketing materials. Opinions might be sought to confirm compliance. Then the AED significantly expanded AML-CFT reporting for 2024, now covering all unregulated AIFs. They need to submit annual questionnaires, RC reports, RCR-RID by mid-2025 deadlines.
Or AML focus.
And the AED is signaling tougher enforcement for 2025. This means unregulated AIFs need robust, up-to-date AML policies, procedures, risk assessments, and solid RC reports preparation involves legal compliance input.
Right.
Also, the RCS, the Trade and Companies Register, has new filing rules since November 2024. Transitioning online, mandatory provision of the Luxembourg National ID number, LNIN, for registered individuals.
The LNIN number.
Yes. If someone doesn't have one, RCS collects data to get one created via the state register. Initially voluntary for existing registrations, but will become mandatory. New forms auto-verify Lux addresses, too. This means updating corporate records, internal filing procedures, maybe board resolutions. It's all driven by transparency and AML goals.
Lots of administrative changes, too.
And remember, the CSSF frequently updates circulars, generally. DORA alignment is one example, but also things like annual MLTF risk questionnaires, specific reports from credit institutions. Firms need constant monitoring and updating, often needing legal advice.
Constant vigilance needed.
And finally, always keep an eye on CJEU jurisprudence from curia.europa.eu. That AG opinion on LPP and tax matters could be huge if the court follows it. Other cases constantly shape EU law interpretation relevant to opinions, especially in finance, company law, cross-border issues. Significant CJEU rulings can force immediate changes in legal advice and opinion content. Luxembourg lawyers have to watch the CJEU closely.
So summing up these developments.
It means entities in Luxembourg need to review and amend a vast range of legal, contractual, operational documents. Key areas: DORA, MiCA, ESMA fund names, AED, AML expansion, RCS filings, general CSSF circulars, CJEU case law alignment. Documentation is dynamic, needs continuous adaptation, often requires expert legal input and compliance opinions. The EU drive for harmonization and transparency is clear and shapes future due diligence for opinions.
It really sounds like a very active and evolving landscape. So looking ahead, what are the key takeaways in the overall outlook for legal opinions in Luxembourg?
Well, navigating this rapid regulatory change is the big challenge. It demands constant vigilance from firms and advisors. Proactive monitoring is essential.
Stay ahead of the curve.
Exactly. And there's a growing need for specialized legal expertise, crypto, digital resilience, sustainable finance, complex AML. Effective practice needs an anticipatory approach, understanding draft laws and trends.
And the opinions themselves.
Their value hinges on robust due diligence by the lawyer and complete correct info from the client. Clear, precise scoping at the start is crucial to manage expectations. Assumptions need careful review. Qualifications must be understood.
Clarity is key.
Absolutely. And despite some standardization trends like the MiCA are key opinions, the core function of legal opinions remains vital. They provide expert, independent confirmation, facilitate deals, ensure compliance, mitigate risks fundamental to Luxembourg's financial markets.
So they're here to stay.
Definitely. As Luxembourg adapts to EU rules while staying a top financial center, demand for high-quality, well-reasoned opinions will likely grow in complexity and scope. Legal tech might help, but expert judgment and responsibility remain indispensable.
Right.
Opinions are critical for legal certainty, risk management, and upholding the integrity and reputation of Luxembourg's marketplace. That compliance premium of operating here contributes to stability and attracts quality business, and opinions are key in showing that commitment.
A really insightful overview. That was the Luxembourg Fundcast, taking a deep dive into legal opinions.
We hope this exploration has given you valuable insights into this critical aspect of Luxembourg's legal and financial world.
Remember to hit that like and subscribe button for more in-depth analysis on key topics shaping the Luxembourg financial landscape. This has been the Luxembourg Fundcast.